but she sends her best regards, and she will be involved in the ultimate decision-making in all of these cases because she's either listening to the live stream or will be listening to the recording after the fact. So ordinarily there are 7 of us on this court, but we have a vacancy right now, so we're down to 6. And of course the chief isn't here today. But at this time we're going to have our colleagues introduce each other, well, themselves actually, starting with our junior-most justice. That'll be Justice Douglas. If you lead off, please.
Good morning. My name is Wayne Douglas. Thank you for having us here. It's a pleasure to be in Lewiston today. I have been on the bench, mostly on the trial courts, for about 20 years, and I've been on this court for approximately a year and a half. And we sit in different, we all have offices in different places. In this state, the Supreme Court is not in one building, but we do get together, obviously, for arguments. But my chambers or office is in Portland.
And good morning, I'm Associate Justice Rick Lawrence. I'm from Portland. My chambers are in Portland. I have been a member of the judiciary for 24 years, 22 of which were serving on the district court, and I've been on this court since May of 2022. It's a pleasure being here today and seeing everyone here.
And I'm Catherine Connors. I've been on the bench since February 2020. I am from York County, and my chamber is in Portland.
Morning, everyone. My name is Andrew Horton. I've been on this court for about 4.5 years, and before I became a member of this court, I was a trial judge for about 20 years. I became a judge in 1999, and before that I worked at a law firm. And while I was a trial judge, I think this is true also of Justice Lawrence, he and I spent a lot of time here in Lewiston, at the Lewiston court, while we were working as trial judges. And it's great to be back. Thank you for having us here today. We go to high schools every October. We've been at Messalonsky up in Oakland on Tuesday. We were at Deering High School in Portland yesterday, and here we are today. We really look forward to this occasion, and we appreciate your inviting us.
As I said, my name is Andrew Mead. I've been a judge for 34 years, the last 18 of which have been on the Maine Supreme Judicial Court, the law court. My chambers are principally based in Bangor, but we hold forth in Portland and Augusta and Bangor and in the high schools in October. So I want to acknowledge some very important folks who are here today who have made this possible. If you're present, would you please stand or give us a wave? Senator Peggy Rotundo actually was a key player in this, but she is back at the legislature doing the important work they have to do there. Also, Representative Kristen Klucher is present here. Thank you again for the invitation. We also recognize Representative Margaret Craven and Representative Mana Abdi, who I guess other obligations. Also want to thank Jonathan Radke, principal of the high school here, for making this all possible. Also, special thanks to Representative Adam Lee, who's not only a member of the legislature and the Judiciary Committee, but he is also the lawyer of the day who will help organize things smoothly as they move along. Also want to give a nod to Doug Dumont, the assistant principal, who is the coordinating faculty who made this possible. I'd like to recognize the custodial staff. Thank you for the accommodations. Also the AV folks who set things up. And special thanks to the Blue Devils football team who apparently set up all the chairs here. And as I said before, with that sort of precision, if they're executing their plays with that level of detail, you'll be in good hands altogether. We are an appellate court, which means we don't have trials. When someone has a trial in the courts of the state of Maine and they don't like the result, they can appeal it to us. And if they're appealing it, they have the burden of convincing us that something went wrong down below, a mistake of law, a mistake of fact. We review that. We hear oral argument in many of the cases. And then we, meaning usually it's the 7 of us, but we have a vacancy, but the 6 of us will convene afterward and debate it and issue a decision, which becomes the law of the state of Maine. We'll cover more on that later. but I believe we're ready to get underway with our next case this morning. This is Penobscot, docket number 23-502, State of Maine versus Debbie Anderson. The matter is in order for oral argument. At this time, I'll have the attorneys stand and introduce themselves. First, for the appellant. Good morning, Attorney King. And for the state.
Good morning, Your Honors. Mark Rucci, for the appellee, State of Maine.
Good morning, Attorney Rucci. We are ready to get underway with our oral argument. Attorney King, we would be happy to hear you on behalf of your client.
Good morning. May it please the court. Michelle King for Debbie Anderson.
Yay.
Let me start over.
Oh, better. Okay.
Thank you.
Yep. That's
Good morning, and may it please the court. Michelle King for Debbie Anderson. Ms. Anderson was convicted of OUI drugs on September 21st, 2023. She was sentenced to a mandatory 7-day jail term as a second offender. She lost her license for 3 years, and she was assessed a $700 fine. Her sentence has been stayed pending this appeal. Approximately 2 weeks after her conviction, her trial attorney filed a motion to dismiss pursuant to 17A MRS Section 12, also known as the de minimis statute. That motion was denied. Before I launch into my argument, I need to correct an error in my brief. On page 14, I made the statement that Ms. Anderson was not asked how she felt while driving. That's an incorrect statement, and I apologize for that oversight. She was asked, however, it was her answer that was somewhat unclear. That being said, prosecutorial discretion is an important part of our judicial system, but it's also important to have checks and balances. The de minimis statute provides such an important check on prosecutorial discretion. Its purpose is to provide flexibility in the administration of justice. When faced with the opportunity to apply the factors set forth by this court in Carger, the trial judge, as the state concedes, did not fully address these factors. The state argues, however, that this court is not in a position to assess those factors because the lower court failed to do so and because the state had no opportunity to answer the newly submitted evidence. As the trial court noted, however, the state declined to respond to the motion to dismiss, and therefore the state had the opportunity, they just declined to take it. Further, that the trial court failed to address the Carger factors does not equate to a lack of evidence before that court to do so. There was sufficient evidence before the lower court.
I see the green lights on, so why don't we jump right into it? As we know, the state of Maine's operating under the influence laws are very literally strict. It's a strict liability statute. And a person is guilty of operating under the influence if they operate a motor vehicle while their mental or physical capacities are affected to any extent or to any degree. Do you agree with that statement?
Yes, Your Honor, I do.
I hope you do, because that's the instruction we give in every trial that comes before us. So,
I'm with you so far.
okay, all right. So it's a very strict law, and in this instance here, as you know the facts, I'll just recite them. But your client takes a number of medications, and I think she listed 11 that she had taken at the time, and she was driving, and she felt her head was getting kind of fuzzy, hazy at some point, and she was headed from one location to a convenience store to use the restroom there. So she gets to the convenience store, and the clerk inside noticed that she parked rather oddly. I think you said her vehicle pulled 3/4 of the way into the parking space, but looking at it here, it's barely into the actual park. Someone would walk by and say, that's an odd way to park there. And the convenience store clerk saw her kind of stagger in, very unsteady onto her feet, to the point that the clerk came out and sort of helped her to a counter, and then she ducked into the bathroom. So the clerk called the authorities and said, I think there's a medical event going on here. They came in, and the officer made observations that led him to believe that she was under the influence of something, and she acknowledged that she was taking all these medications. He's a drug recognition specialist and concluded that. So Under those facts, do you agree, well, you probably won't agree, but the state has to prove that she was under the influence while she was operating the motor vehicle. And that's one of your principal points on appeal, that did the state prove that she was under the influence while she was operating?
Yes, Your Honor, that's my second issue, that the state failed to prove that she was impaired while she was operating, correct?
And the evidence against that would be that she did say she was noticing something that was happening, I forget her exact words, fuzzy or...
I believe she said she was lightheaded and her vision was
Lightheaded.
blurry, and then she immediately pulled into the gas station.
And then we have witnesses who observed her physical manifestations there. So it would require the trier of fact, a judge or a jury, to say, okay, well, if she's staggering at the point where she walks into the store and she just pulled into the parking place, we would infer that she was under the influence. That, you with me so far on that?
Yes, Your Honor.
Okay. Under the circumstances here, you have tendered what they call a de minimis offense, which means in Latin, I think, of little. And the idea is that, well, she may have been under the influence and she may have driven, but it was so minimal that the judge really shouldn't accept that as a defense to this case. Just looking at the facts I just indicated here, they don't seem on their face to be that level of, I mean, de minimis basically says they did something, but that really wasn't the evil that the statute's intended to prevent. But if she operated under the influence, that is the evil the state intended to prevent. So I've taken up a lot of your time here. I'm going to hand off to you, and you can respond to the questions I've posed here.
Yes, Your Honor. I would submit to you, or to all of you, that under the statute, in either subsection B or subsection C, the motion to dismiss should have been granted. Subsection B actually provides whether or not the defendant actually caused or threatened to harm the cause prevented by the underlying statute, in other words, the OUI statute, to an extent that was so trivial. And as you've noted, the evidence in this case was that, well, actually, let me back up. The evidence in this case was that on the morning of this incident, Ms. Anderson had taken her medications that were prescribed to her by her doctor in the exact fashion prescribed to her by her doctor. She said that she took her friend to the police station and that during the course of the morning, she felt completely fine from her medications. At some point while she was waiting in her car at the police station, she had to use the restroom, but she knew she couldn't do that at the police station because there were a number of stairs that she couldn't take, and she had a very bad back and had a number of back surgeries. So she decided to drive her car over to a gas station where she could use the restroom. She said all that morning she had felt fine, but as she was pulling into the gas station, she had blurry vision and felt lightheaded. It was at that point that she pulled into the parking spot. Halfway, 3/4 of the way, it's a little bit hard to tell from that picture, but certainly not fully all the way in. She walked into the gas station, and at that point, her gait was off, as noticed by the clerk. Ms. Anderson testified that this was due to the number of back surgeries that she had, and in fact, the officer testified that he couldn't rule that out as a possibility for her unsteady gait.
Well, your de minimis argument hinges entirely on the defendant's testimony. In other words, that she felt fine until immediately pulling into the gas station. Was the jury required to believe your defendant's testimony?
Well, the jury is required to look at the evidence, Your Honor, and there was no evidence to the contrary. There was no evidence of impaired operation prior to her turning into the gas station whatsoever. So while the jury didn't have to believe her, they couldn't make up evidence of impairment as she was driving down the road before she pulled in
You agree
there.
that there is evidence of operation. Pulling into the parking space is operating a motor vehicle, correct?
There is absolutely evidence of operation, Your Honor, 100%. What I'm saying is there was no evidence that as she was driving from the police...
How long she'd been operating while impaired?
The testimony was that the gas station was just down the street from the police department. I don't believe that there was any testimony as to 1 mile or half a mile, but the testimony came out that it was just down the street.
Counsel, I hear your argument that your point is that there's no direct evidence that Ms. Anderson was operating impaired. There is evidence that when she pulled into the gas station and attempted to park the car, she did that in a haphazard or odd or incomplete way. When juries are instructed at the end of a trial, they're instructed on both direct and circumstantial evidence, and on that they are permitted to make reasonable inferences from facts that have already been proven beyond a reasonable doubt. Isn't that what the jury did here? So didn't the jury, as a matter of fact, make a finding that Ms. Anderson operated while impaired?
Certainly, Your Honor, in convicting the defendant, the jury must have come to that conclusion.
Okay,
If
so
we're
then-
looking, I'm sorry.
Then I want to go to factor B, which is did not actually cause or threaten the harm to be prevented. The harm to be prevented by this law is to prohibit and discourage people from driving while impaired. How do you reconcile what the jury found and what you're arguing here today, namely that that factor B is a basis for a de minimis ruling?
Yes, Your Honor. I would argue that the danger to society, to drivers as whole, is the purpose of the OUI statute. In other words, having people who are driving while impaired on the road, the danger that causes is the harm that the statute was enacted to address. In this case, there was certainly no actual harm. Ms. Anderson didn't hit another car. She didn't drive herself off the road. She didn't drive in a manner, at least there's no evidence of, she didn't drive in a manner that swerved at another car, that perhaps swerved at a pedestrian. So I would argue that in this case, there was no actual harm or no threat of harm, and any threat whatsoever was so trivial, so minor in this time period in which Ms. Anderson was driving from the police station to the gas station. And the trial judge, in addressing this, seemed to address the timing factor, how long or how far she had to go. And I would suggest to you that that issue is important as to whether it's trivial or not, but it's not relevant as to whether or not the underlying statute was, there was a proper violation. In other words, when you look at the trial judge's decision, he didn't properly address whether or not such a short period of time on this case, in this case, was trivial.
Well, your argument would be quite a bit stronger if Ms. Anderson had been found pulled to the side of the road, as opposed to driving to a destination and attempting to park, wouldn't it?
Well, Your Honor, no, not in this circumstance, because again, if we believe Ms. Anderson, and we have no evidence otherwise, Ms. Anderson said she began to have blurry vision and felt lightheaded as she was pulling into the gas station. So when she got into the gas station, that's when she pulled over. If she would have said she had those symptoms just as she left the police department within 100 yards, I may agree with you. But in this case, she said she pulled in as she was pulling in.
But again,
she was having
you're
those
hanging
symptoms.
that on your client's testimony. I mean, she was found guilty of operating under the influence, which means that the court found she was operating a vehicle while she was under the influence. Operating a vehicle while under the influence is the hazard that the statute is intended to prevent. So if a person is impaired to any degree, they're operating on the road, that's the hazard. And it's not de minimis. How can we say it's de minimis? That's exactly what the legislature had in mind.
Well, Your Honor, and again, we have to look at this at a case-by-case basis, and I'm not sure what else Ms. Anderson could have done in this circumstance. As soon as she started feeling ill, she pulled into a parking spot. And I don't think we want to encourage...
I don't mean to interrupt, we're running short on time. So at a certain point, according to what you're saying, we take it at face value, she realized something's going on, and she pulled in almost immediately thereafter. I just want to make clear, in case anybody's listening out there, the fact that a person's on a prescription medication is not a carte blanche to drive. If you're under the influence of a prescription medication, you're violating the law if you operate a motor vehicle. And also, we did have a case, I can't recall the name, maybe the state's attorney can remember it, but a gentleman had a prescription for medication. He drove, he didn't feel that he was under the influence. He may have been influenced by the fact that he had the medication, but he committed the offense of operating under the influence. So I'm just circling back to your point that she didn't feel, that she was under the influence except for this hazy feeling, but there's a court finding that she was under the influence while she operated. How do we reverse engineer that into a de minimis defense?
Well, Your Honor, I would like to address the Curtis case because that case is quite different than this case. And in that case, the defendant admitted that there was a warning label on his prescription drugs that he
Right.
shouldn't operate a car while taking the drugs. In this case, Ms. Anderson followed completely her doctor's orders to increase her medication. And
She was taking a
there was every
narcotic.
reason
She
to-
was taking Vicodin. She'd been taking Vicodin for years, which is a narcotic. Benadryl, which is makes you go to sleep. And was it Ambien? No. What was the medication she had here? Abilify.
Abilify was the new one, Your Honor, and she testified that her doctor had told her to gradually increase her doses, which she had exactly done. And she testified that morning that she felt perfectly fine. She had every reasonable belief to believe that she was going to be fine driving.
And I'm going to exercise my prerogative as acting Chief Justice. I cut you off as you were talking about the Curtis case and why we should treat this as a de minimis.
Oh, yes, Your Honor. In the Curtis case, as I was saying, that defendant admitted at trial that his prescription bottles had a warning label that said, do not operate a car while taking these. In this case, Ms. Anderson, again, followed her doctor's orders to the T. She gradually increased the Abilify, which she had started, she was on her third day, on the day of this. And there was no evidence whatsoever that came in that she was, for any of the medications that she was taking, that she was cautioned that she shouldn't drive. And in fact, as you noted, she was on Vicodin for a number of years, and she said she had never had any ill effects or had never felt drowsy having taken any of her prescription drugs previously.
All right, and you have waived rebuttals, so thank you for your argument
That's
here
it
today.
from me. Thank you.
Okay. Attorney Rucci, we'd be happy to hear you on behalf of the state.
Acting Chief Justice, and may it please the court. The principal aims of the de minimis statute as relevant in this case are twofold. To shield from the condemnation of conviction those individuals who violate the law in such a trivial way that to saddle them with a conviction works an injustice in that case. And as in Cargar, to dismiss prosecution where admittedly criminal conduct occurs in a context which the legislature could not have envisioned in defining the crime at issue. Here, Ms. Anderson, an individual with one previous OUI conviction already on her record, took a full dose of a new medication and several other medications as administered by her partner while on notice from her doctor that she should slowly ramp up the ingestion of the new medication in order to see how it affected her. That, in this case, the effect was adverse to her motor and cognitive functions, and she got behind the wheel of a car. The evidence shows that she operated on a way while her mental or physical faculties were significantly impaired, putting other travelers in danger and exemplifying exactly the type of conduct that the legislature sought to criminalize in enacting a statute with no mens rea requirement. The risk to which Ms. Anderson, subjected others in the case was not trivial, and the facts are not so aberrant that they defy legislative consideration. The judge did not abuse his discretion in denying the motion to dismiss, and the conviction of the trial court should be affirmed. And at that point, I would open the floor for questions.
You mentioned de minimis. That's a defense that is often tendered and seldom successful, although my colleague to the right, I think, has like the leading case on de minimis in the state, so I'll let her talk to that later. But in this case here, if in fact we accepted Ms. Anderson's statement that I really didn't feel anything until after I parked there, isn't the element of operation missing if we
No.
accept her testimony?
No, because operation is defined extraordinarily broadly under the state law. And I'm not even sure I correctly heard your question. I'm having some trouble. But I think what you asked was there, can I prove operation in this case?
Yes, yeah, that's what it
Operation
was.
is defined as operation or any attempt to operate. So under Maine law, operation here is, I would respectfully suggest to the court not at issue.
So here's the hypothetical, the dreaded hypothetical. Not that dreaded.
That's an ominous sound because the dreaded hypothetical is. All right, now with that.
Okay? Just one at a time, I guess.
One at a
for now.
time.
All right. So, dreaded hypothetical.
Sure.
So the answer is not, that is not this case. So, what if, as is being argued, but stripping it of some of its facts, you are taking a drug that you've been taking for a long time, and it works perfectly fine, you drive, no problem. You're driving along, and all of a sudden you get double vision. You immediately go to the side of the road. Is that a case that is ripe for de minimis?
It would depend on other factors that the court outlined in Kargar as taken from the Model Penal Code and as taken from Hawaii precedent. But on those facts, I mean, I would think consideration of the defendant's criminal history would be important. A number of factors which might need to be determined at a testimonial hearing that are relevant under the Kargar analysis. But potentially, yes. I would agree with you, Your Honor, that seems to be...
Okay, so she's saying that what I just outlined was the situation. So what are and you said we have to look at context. So what are the added facts in this case that say it's not a subject to the broad discretion for de minimis application?
Sure. The added facts in this case, when we look at the purposes of the de minimis statute, the background and experience and character of the defendant is important. This was someone with a previous OUI conviction. Knowledge of the consequences to be incurred. She would have incurred some version of those consequences prior, despite the fact that there is a prior alleged it's the same exact class of crime. It's subject to different mandatory minimums, of course. Circumstances surrounding the conduct, I would suggest that just because the jury heard that the defendant felt dizzy for the first time right as she was entering this parking lot, they didn't need to accept that testimony in light of the other evidence that was in the case that she could barely, frankly, stand up by the time she got into the gas station. They could have rejected that testimony and said, we thought she was likely feeling it earlier while she was on the roadway.
Well, what's the evidence, now we're going to sufficiency, what's the evidence that proves beyond a reasonable doubt that she didn't immediately, as soon as she felt dizzy, that was when she was pulling into the parking lot?
There isn't any evidence that the state offered that would directly contradict that, but just because that's true does not mean that the evidence is insufficient to support a conviction. The truth of the matter here is that she was operating a motor vehicle and was under the influence, impaired however slightly or to any extent by the ingestion of alcohol, or a prescription drug, which is how this court instructs juries, and that is enough to satisfy a conviction in this matter.
I'm going to go a little off topic here today and put you on the spot.
Sure.
A person is driving on a 4-lane highway, and suddenly, as a result of a new medication they received, realizes, wow, boy, something's wrong. I'm feeling the effects of this. I'm feeling fuzzy. My judgment's off. And there is a rest stop just a quarter mile up the road. So this person knows that they're under the influence. They know it's against the law because Maine has a very strict operating under the influence law. Would the competing harms doctrine immunize that person if they stay operating under the influence and hold on to get off the highway so they don't cause, he's in the far left lane too, he's have to cut across the lane of traffic. It's hypothetical, it's policy, you don't have to answer if you're uncomfortable with it, but I'm just wondering whether that would apply.
I would think that it would depend on circumstances that would need to be developed on the record, such as traffic patterns. There may be an instance where it's perfectly safe to pull off to the side of this 4-lane highway and not cause any issues at all. Or it could be the instance that, I'm going to New York right after this with my family, a dog and 4 kids. Maybe I or my wife has that circumstance and thinks, I cannot safely pull over to the side of this 4-lane highway and not risk my family's safety, in that case, maybe there is a colorable competing harms defense. I know Justice Connors told me not to say this during her hypothetical, but that is not this case.
Absolutely not. And for those in the audience here, you just heard a very astute and very appropriate answer. It's 2 words, and it will serve you well as a lawyer if you go into law. It depends, right? It does depend, and that's a fair answer, an appropriate answer.
And
Further questions?
Well, bringing you back.
Back to reality.
Bringing you back to this case, wasn't there evidence that reflected that when confronted by law enforcement, the defendant indicated that she thought the medication had affected her, correct?
I think she said she was a 9.
Well, I was going to get to that.
There
First,
was
she
a-
just said it affected her, and then asked on a scale of 1 to 10, what did she indicate?
Yes.
That
She said it affected her, and then she said she was a 9, and there was some back and forth, but Lieutenant Benjamin asked her, when you were driving, how were you feeling? And she, irrespective of the fact that she later said she felt that it had to do with dehydration or a medical event, she admitted at the time that she felt impaired.
And couldn't the jury infer from the way the car was parked with the other evidence that came in that, in fact, she was impaired while she was operating the motor vehicle?
Yes, and I would say, that the evidence the jury had before it the picture that Justice Meade held up to Attorney King during her opportunity to argue, and that, to the state's eye, is colorable evidence that this person was operating in a manner that was inconsistent with someone who was not impaired.
And do I recall correctly that the evidence suggested at one point she indicated that she was feeling better and was going to drive home, but the Sergeant Benjamin had to prevent her from doing that?
If I heard your question correctly, I do believe at one point she said, "I'm feeling much better now," and in fact, EMS came and checked her out and determined that this was not a medical event that required transportation to an emergency care facility. And that at that point, that is when Lieutenant Benjamin continued with his evaluation, with his roadside investigation, which really occurred in a parking lot. And if there are no further questions, I'll rest on my briefs.
That appears to be the case. Thank you, Attorney Rucci, and rebuttal has been waived, so that concludes our oral argument. We do thank the attorneys for their briefs and oral argument here today. We'll take the matter under advisement and issue a decision in due course. What that means, you'd probably like to know right now whether or not we're going to sustain or overturn this operating under the influence conviction. But the 6 of us will gather in our chambers, and we will debate it amongst ourselves, share our opinions, and eventually issue a written decision. If everyone agrees with that particular decision, that's called a unanimous decision. But occasionally, some of us may disagree and feel that the approach is slightly different, and they may issue a dissenting opinion. The majority still governs the day, but a dissent sometimes will signal that the law might be uncertain, which I see a bunch of folks from the case coming up later. We may hear that again here today. But a dissenting opinion allows the judge to say, we don't sign on to what the rest of them are saying, but the majority still controls the case. So again, thank you for your attention here today. If there's nothing further, we'll take the matter under advisement, and court will be in recess.